So Tallgrass Estate Planning is a law firm that's based in Tulsa, but we operate in Stillwater and Oklahoma City, and also in Seattle, Washington. So up in Seattle, we're Tallgrass Northwest, and we've got some clients up in the Pacific Northwest as well. Sometimes people stop and wonder why in the world would we pick those two locations, and it's my wife's fault. Her family is from the Washington area, so we split our time between Oklahoma and Washington, and we've got clients and attorneys in both locations. So we are focused exclusively on primarily trust and asset protection planning, but we also do, wills and powers of attorney and probates and guardianships and some elder law. The elder law we do is exclusively related to eligibility for Medicaid and VA benefits, so we're not doing elder abuse and some crisis planning, but we are doing a lot of kind of look-ahead planning for aid and attendance benefits and for Medicaid purposes. So if anybody has questions about the firm or how we practice, I'm always happy to interact offline at any time. So feel free to reach out and ask if you'd like. So without any further ado, unless there's some more particular questions I can answer up front, I'll just launch into the topic for the day. So I want to double check again that everybody is seeing the slides that say standalone retirement trust drafting considerations after secure. Is that visible to everyone? Okay. So what I wanted to talk about primarily today were these four things. First of all, what is a standalone retirement trust? I can't see everybody's picture. I know that there's a lot more people logged on than who I can see at the moment. But if you have actually drafted or done some standalone retirement trust planning, can you give me a high sign on that? I want to get a sense of whether or not I'm talking to people who have or have not done this. Okay. So some of you are going to be familiar with what a standalone retirement trust is. And if you have some color commentary to add to what I described, please feel free. We'll also talk about the SECURE Act, which has been recently passed. We'll talk more about what it does and how it affects retirement trust planning. I won't get into the details of how it affects, employment plans for 401ks and IRAs. We'll talk more about how it affects transfer of benefit upon death of the plan contributor. We'll talk about some drafting errors to avoid in a standalone retirement trust now that the SECURE Act is passed. And then the last thing we're going to talk about may make no sense to some of you right now, but it will, hopefully, if I do my job right in the next hour. How do we avoid this new 10-year rule and kind of recapture the stretch for an IRA benefit? So first thing we're going to talk about is just what a standalone retirement trust is. A standalone retirement trust may be revocable or irrevocable, but what really defines it is that it is created specifically and only for the purpose of receiving tax-deferred retirement plans at the plan contributor's death, or at some time in the future, maybe after the spouse's death. But this is essentially an empty bucket during the grantor's lifetime. It doesn't own anything until the grantor has passed away and at a time designated with the custodian of the funds that the trust should become the beneficiary. That's all. Now, what it's for is simple enough, but how to draft it effectively is kind of where it becomes complicated. So if the standalone retirement trust is drafted properly, then it allows the grantor to do three really significant things. And these are the 3 points that we talk through in our counsel with our clients. It can do a lot, but these are the highlights. So the first thing that a standalone retirement trust can do if drafted effectively is minimize any annual income tax liabilities. Rather than absorbing those all in a single year, it can stretch them out over a number of years. So there's not any one year where all of that becomes regular income to the beneficiaries and they take a big tax hit. The second thing that it can do, and this is related to the first, is because it's keeping a certain amount of principal invested in the retirement plan, we're continuing to take advantage of tax-deferred growth. So the twin tax concerns that grantors have with this kind of trust is, number one, they don't want to create a massive income tax liability for the beneficiaries in any one year, and they also don't want to cut off that potential for future tax-deferred growth. So we make those two things work together inside of the SRT if we've drafted it effectively. And then the third thing that we do is actually provide some ongoing asset protection for the beneficiaries from their own financial bad choices or bad luck. I'll talk in more detail about what that issue is in just a moment. Oftentimes, individual clients and sometimes even attorneys, if they're not familiar with the retirement trust, are surprised to find out that inherited IRAs are exposed to the beneficiary's financial bad luck. But they are, in fact, and we'll talk about why that is and how we can avoid it. So why not just name a revocable living trust as the beneficiary of an IRA? Let's kind of get that out of the way to beginning. Now, first of all, there are times where that's perfectly appropriate. We have plenty of clients who name their revocable living trust or the sub-trusts in a revocable living trust as the beneficiary, contingent beneficiary of a retirement plan. And sometimes that's perfectly appropriate. But why might a client not want to do that? Why might they create this additional standalone retirement trust? Well, first of all, they might have very different goals for their IRAs and 401ks, so tax-deferred accounts versus their real estate, brokerage, business interests, etc. They might have a very different way that they want those things to be administered or benefit their family, the children, spouse down the road. Especially if it's a blended family scenario and they've got a very different asset mix and how they've invested in their retirement plans versus the non-tax deferred assets. So different goals is one reason we might create the standalone retirement trust. The second thing is that the RLT, the way that the revocable trust is drafted, may not provide sufficient ongoing asset protection. It may be that the revocable trust assets, primary residence and some life insurance, death benefits or whatever, you might want them to become available to the beneficiaries at certain ages or under certain conditions that remove asset protection as one of the benefits of using the revocable trust. Whereas if there's been significant lifetime investment in a tax-deferred account, you may want to stretch out that asset protection benefit over and above what the revocable trust does. So differentiating the asset protection provision can be important. The revocable living trust may include what are called non-designated beneficiaries, and we'll talk more about what this means in just a moment. But the point is that the revocable trust may have something like maybe a 10% tithe to their church at death, or a charitable distribution, or a class of beneficiaries that don't have what the IRS would consider a life expectancy. And that would completely destroy the ability to stretch the IRA benefit out over any amount of time beyond 5 years. So if the revocable trust has a charitable distribution or non-designated beneficiaries, naming the standalone retirement trust as the beneficiary of tax-deferred accounts is going to become really useful for that purpose. Everybody else hearing that? I think somebody needs to mute if they can. So the other thing we need to think about is the potential for ongoing estate planning work. You're going to draft a retirement trust for somebody now, or at some point in the future, and along with your revocable trust. If the revocable trust is all you've drafted and it has special provisions for retirement assets, and then 10 years down the road that client hires another attorney to do an amendment or a restatement, and either the client or the attorney doesn't do a careful reading of your trust, they may destroy all the provisions that you've created for the retirement plan. So protecting the provisions for retirement assets from future restatements is also a reason to create this separate bucket for the standalone retirement trust. And you may simply wish to create an irrevocable trust from the very beginning for retirement plan purposes and not a revocable trust, and that would be another reason to differentiate and create the separate trust. So why are we worried about asset protection? That's going to be a running theme here, and there's a good reason why we need to think about it. So for the plan contributor, at the point where your client is still alive, their IRAs, their 401ks, depending on the type of asset they have, is already protected from their own, bankruptcy, civil lawsuits, creditors, etc. And some clients believe mistakenly that same asset protection carries forward to their beneficiaries. once the kids inherit the IRA, they get the same asset protection from their own creditors, bankruptcies, etc. That's not the case. Some of you may be familiar with the 2014 Supreme Court case Clark v. Ramaker that made it very clear in a unanimous decision that inherited IRAs are not exempt from creditor claims under federal bankruptcy exemptions. So, kiddo receives dad's $1 million IRA from his time at ConocoPhillips, and then goes bankrupt, thinking that the inherited IRA is going to be protected. That's not the case. If we want protection for inherited tax-deferred accounts, we need to create special provisions for that purpose. But naming the kids as individual beneficiaries is not going to provide that benefit. So the SRT can solve that problem at least for a while after the Secure Act, and we'll talk about that. So I want to pause for just a second and hop off of my screen share and open my chat window. Are there any questions so far about what the SRT is, why you would create it versus just naming the revocable trust as the beneficiary before we jump into the Secure Act portion? So somebody asked, does Clark apply to rollover spouses? So the spouse gets the benefits under ERISA and state law for asset protection, but downstream beneficiaries may not. Can everybody see me, or are you still seeing my screen? Okay. So yeah, we don't necessarily have to worry about asset protection for spouse. Oh, hi, Brandy. They're gonna get those benefits, but it's those contingent beneficiaries, children, etc., that lose those asset protection benefits if we don't make specific provision for them. Any other questions about what the SRT is before we jump in? Okay. So let me go back to this.
Yeah, you just got a question, Riley, on can you have a joint SRT for spouses?
No. So an SRT is an individual trust, not a joint trust. You can make the trust the primary beneficiary of an IRA and make the spouse the primary beneficiary of the SRT. But there's not right now we can't create a joint SRT that receives both the husband and wife's IRAs or 401ks. In the same way that an individual has to have their own IRA, you can't have a joint IRA with your spouse. You also can't have a joint standalone retirement trust. It's an individual instrument, not a joint instrument. So let me skip forward here a little bit. Now, so what is the Secure Act? The Secure stands for Setting Every Community Up for Retirement Enhancement. And it's an act that was passed, it was signed into law last December. It's been talked about for more than a year. And a lot of us were thinking we were going to be free of this thing last summer. It got a lot of attention last late winter and early spring, so quarters 1 and 2 of last year. We really thought this was going to pass. And then in the summer, Ted Cruz, of all people, halted its progress, because it didn't have sufficient provisions for how these monies could be used for homeschooling education. And we really thought it was going to be just stuck in Congress for a while, and we were going to be free from this thing. It got some more attention late in the year and passed. So it was signed into law last December, and it became effective as of January 1st of this year. It's a little hard to find. If you go looking for the Secure Act, you're going to have to go to the Further Consolidated Appropriations Act of 2020, Section O. So it's not the most intuitive thing to go get to, but if you want to read the entire act, that's where you would go to find it. There's a lot that it does that we're not going to talk about. What I do want to point out here in this presentation are a handful of key provisions that are going to affect trust drafting and estate planning. So probably the provision that's created the most controversy and is going to give you the biggest headache is this new 10-year rule. So Prior to Secure, you may or may not know that depending on who your beneficiaries were of an IRA or a 401k and how they were designated, they could take their own life expectancy to calculate their required minimum distributions every year and stretch the benefits of their inherited IRA over their lifetime. Now, the RMDs were going to go into effect pretty quickly. The IRS was certainly going to start collecting some income taxes, but they were going to be able to spread those out over the beneficiary's lifetime. Now, under the Secure Act, the new general rule, with very few exceptions, is that all inherited IRAs, 401ks, tax-deferred accounts have got to be completely distributed within 10 years of the plan contributor's death. So this no longer gives us the lifetime rule for the beneficiaries. We now need to distribute within 10 years. And for a lot of clients who have saved aggressively in IRAs and 401ks, this is pretty disappointing. This means that there's going to be a pretty big income tax consequence within a relatively short period of time after their death. Now, the Act, though, does create a new class of beneficiaries called eligible designated beneficiaries. There was already provision for what are called designated beneficiaries and non-designated beneficiaries, and we'll talk about that distinction in just a moment. The point here is that there are certain EDBs, eligible designated beneficiaries, that may still use their own life expectancy to calculate RMDs. They don't. The 10-year rule does not necessarily apply to them. And those classes, those EDBs are a spouse. So it's still that if you pass away and name your spouse as your primary beneficiary, they can use their life expectancy to calculate RMDs. They're not subject to the 10-year rule. Minor children, and minors here is going to be defined by state law. So depending on the state's UTMA rules, it may be 18 or 21. But minors that inherit while they're minors, the 10-year rule does not start until they reach the age of majority. So somebody inherits when they're 8 years old. Their life expectancy is what controls until they're 18, and then the 10-year rule applies, and they have a total distribution by age 28 or 31, depending on the state. Another class of EDBs are disabled and chronically ill. And then the last class of EDBs are those beneficiaries that are less than 10 years younger than the plan contributor. All right, so what this does is it really excludes most people's healthy children. If they name them as their contingent beneficiaries, they're going to be subject to the 10-year rule. Some other key provisions that are about the EDBs, the eligible designated beneficiaries. Number one, the EDBs are determined at the plan contributor's death, not beforehand. We don't know who these people are until the plan contributor dies. We can guess. This is kind of like some of you may have gone through the maybe the intellectual exercise with your clients when you're doing some planning about identifying who their heirs are. Of course, the punchline there is we have no idea who your heirs are until you die. We don't know who they are right now. We know who they might be, but they cannot be determined until you passed away because they're a class of people that only exist when you pass away. Similarly for EDBs, you can't know at the time that you're filling out a beneficiary designation whether or not you have an EDB. Their class, their status is only determined at your death. And the other thing that the Secure Act affects about EDBs is that their status doesn't change once it's been determined. So if you have a child who inherits and they are relatively healthy and neurotypical and they don't fall into one of the EDB categories, and 5 years later they develop a disability or a chronic illness, they do not get to change their status. They are still subject to the 10-year rule. They don't get to go from 10-year rule to life expectancy. If they were determined to be an EDB at your death, then they will always be an EDB. If they were not an EDB at your death, then they will not become an EDB in the future. Does that make sense? Now, some of this, because this is such a new act, like everything else that the IRS is part of their code or Congress here, we're going to need some regulations to sort out the details. So with some of these provisions, I'm taking a kind of a conservative approach to interpreting the act, and we'll see where this ends up and how the IRS handles some exemptions. But this is the best guess right now under the clear reading of the law is status doesn't change once it's been determined. Now, what about when the EDB passes away? Are there any rules that affect how things function then? And the answer is yes. So if upon the EDB's death, so let's say you have somebody who is disabled and inherits your IRA, they get to use their own life expectancy to determine their required minimum distributions. If they die, their beneficiary is subject to the 10-year rule no matter what. It doesn't even matter if their beneficiary would have also been an eligible designated beneficiary. So if your disabled child has their own disabled child, by the time it gets past the eligible designated beneficiary, the next taker is going to be subject to the 10-year rule no matter what. So we don't have cascading EDBs. We have one layer of EDBs, and when they pass away, now we're subject to the 10-year rule no matter what. The other thing that the Secure Act creates for us is something called the applicable multi-beneficiary trust. This is a new category of trust within thinking about inherited IRAs. So what is an applicable multi-beneficiary trust? If you have a revocable trust or a standalone retirement trust that has more than one beneficiary, so it's not just a single person, but a class of individuals or your 3 kids or whatever it might be. So more than one beneficiary, and the beneficiaries are treated as designated beneficiaries. We'll talk about what that means in a moment. And at least one of them falls into one of the categories for an eligible designated beneficiary. Now we have an applicable multi-beneficiary trust. Why does that matter? That does a couple of things for us under the Secure Act. So before Secure, if you had a trust that fell in, it could have been described as what we now call an applicable multi-beneficiary trust. If your trust, the RLT or the SRT, was named as the contingent beneficiary of your IRA, and you wanted each beneficiary to be able to use their own measuring life to determine their RMDs, then on the beneficiary form for the IRA or the 401k, you needed to identify each individual subtrust in order to allow that to happen. In other words, if I had a trust that named Stephanie Jackson as a half beneficiary and Dan Waska as a half beneficiary, and I wanted Stephanie and Dan to be able to use their own separate measuring lives to calculate their RMDs, then it's not good enough to just name my revocable trust as the contingent beneficiary. I need to name the subtrust for the benefit of Dan Waska as a 50% beneficiary and the subtrust for the benefit of Stephanie Jackson as a 50% beneficiary to allow them to do that. Okay, so it was a complicated way to fill out the beneficiary forms if you're going to allow for that stretch. After Secure, if you have an applicable multi-beneficiary trust, then the 10-year rule is going to apply to all the designated beneficiaries. If any of those beneficiaries are an EDB, an eligible designated beneficiary, you do not need to separately identify their subtrust in order to allow them to get the EDB stretch. There's 2 ways that this happens. Number one, if you name your revocable trust or your standalone retirement trust as a contingent beneficiary, and the trust says at the time of the plan contributor's death, this has to be divided into separate subtrusts, no matter what the proportions is, equal or unequal. But it's divided at the time of the plan contributor's death, and one of those beneficiaries is an EDB, then that EDB can use their own life expectancy to calculate their RMDs without specifically identifying their subtrust. This allows you to, maybe all of your children are perfectly healthy right now, but at the time of your death, one of them has become chronically ill or disabled. Then the EDB rules are going to apply to them even if we don't specifically identify their separate subtrust. This also applies if your trust says, I've got my 3 kids as my beneficiaries of my IRA. One of them is disabled, And they are the only one that has the right to distributions for their lifetime. When they pass away, my other children are the contingent or the remainder beneficiaries. Then that EDB is also going to get to use their life expectancy to calculate RMDs for their lifetime. So we're stretching out the benefit over that one beneficiary's life. When they pass away, the 10-year rule applies to the remainder beneficiaries. So we no longer have to go through this exercise of naming subtrusts in the beneficiary form. You can just identify your applicable multi-beneficiary trust as the beneficiary of your IRA, and we've done the heavy lifting for the EDBs. Does that make sense? Okay. Now, did you draft a see-through trust? And Dan, we're at 12:30. Do we need to stop for code for a second?
Thank you, Riley. Let me give the code. So the halfway code is 2409. 2409 is the halfway code. And again, when you fill the form out, turn it into Beverly Petrie, you got to put that code number in there, 2409, which is the halfway code. And again, you got to remember to identify this as course number 112539. So the halfway code is 2409. It's back to you, Riley.
Okay. So Scott asked, when we're talking about minors, are we talking about only minor children of the settlor? And yes. So the minors in question here are, well, actually, no, I shouldn't say that. If you have a class of individuals that are named as the beneficiary, like my grandchildren or my nieces and nephews, and they are minors, then they get to be considered EDBs. So the minors that we're talking about do not have to be the first generation children of the settlor or the grantor. The minors could be any designated beneficiary. Under, we'll talk about the Treasury regs in just a moment to clarify, who's considered a designated beneficiary. But it's not just the minor children of the settlor. It could be any minor that's named as a beneficiary. So let me get back to my screen share here, and we'll pick it up with see-through trusts. So one of the considerations here when drafting a standalone retirement trust, or even a revocable trust that becomes a beneficiary of a retirement plan. Let's see, which of my screens are you seeing my screen that's got the full slides or just no, Stephanie? Okay, let me see if I can fix that real quick. Thank you. So let me try this. How about now, Stephanie? Is that better? You seem okay, great. So a see-through trust is kind of a key part of how this functions. A see-through trust could mean a few different things, but here's the big picture. With a see-through trust, your trust beneficiaries are treated as if they are plan beneficiaries. And that's important. If we want to avoid forcing the 5-year rule, the old 5-year rule, then we need to have a see-through trust, whether it's our revocable trust or a standalone retirement trust. So what is a see-through trust? There are 4 requirements for a trust to be a see-through trust. Number 1, it's just got to be valid under state law. Number 2, it's got to be irrevocable when it's created or become irrevocable upon the death of the plan contributor. Number 3, the beneficiaries have to be identifiable, and that's with reference to Treasury Reg Section 1.401 A9-4. And essentially what this means is that your beneficiaries are individuals or a class of individuals. So that would mean, for instance, a class of individuals could be my children, my grandchildren, my brothers and sisters that are then living at the time of my death. All of these are people that the IRS can see and calculate a life expectancy for. Okay, so that's the key here, is that the IRS knows how to think about their lifespan. If you have a beneficiary that is not an individual or class of individuals with an identifiable life expectancy, you do not have a see-through trust. You have a trust that's going to be subject to the 5-year rule. So that would mean if you named a church or a charity as a beneficiary, they are not an identifiable designated beneficiary within the meaning of the Treasury regs. If you were to say something like, let's say I appointed Dan as my successor trustee, and I said, Dan may distribute this to any beneficiary of his at his sole and absolute discretion. He gets to decide who those beneficiaries are. That's not an identifiable life or class of individuals within the meaning of the Treasury reg, so this would not be considered a see-through trust. So if the trust names individuals or a class of individuals, you could fall into the see-through trust category, otherwise you could not. And the last requirement is pretty simple. It's that the documentation that's described in the Treasury reg has got to be provided to the plan administrator, and that just means you got to show, when you pass away, that you have already or can make available the trust document to the plan administrator, as well as the provisions that describe any requirements for how and when the entitlement passes to the beneficiaries. So if you've met those 4 requirements, you have a see-through trust. The trust beneficiaries are treated like their plan beneficiaries. Now, there are 2, though, categories of see-through trusts, 2 different types of trusts with very different consequences, tax consequences especially for the beneficiaries. You could draft what's called a conduit trust, and a conduit trust is a trust that says all RMDs that the trustee receives have to be distributed to the individual beneficiaries. So there's no question, there's no discretion. RMDs go to the beneficiaries. Now, it doesn't have to say that only RMDs go to the beneficiaries. You could say that your trustee has to distribute RMDs, plus there's maybe HIMSS standards, health, education, maintenance, support. The trustee can distribute discretionary for that purpose, or any other amount of principal, maybe 5% of the principal per year can become distributable to the beneficiaries. But if it forces RMDs to the beneficiaries annually, you've got a conduit trust. You may also have something, though, that's called an accumulation trust, which authorizes, it doesn't require, but it authorizes the trustee to accumulate or to hold RMDs inside of the trust. They don't have to be distributed to the beneficiaries. Again, one of the common points of confusion here is that some people think that an accumulation trust is one that requires the trustee to hold RMDs, and that's not the case. If the trust said that the trust may hold RMDs for the beneficiary, then you have an accumulation trust, not a conduit trust. So how can I make sure that my EDBs, if I have my spouse or a disabled child or a minor child as the beneficiary of a sale and retirement trust or an RLT, how can I make sure that they are not subject to the 10-year rule, but they still get to get to stretch the benefit over their lifetime? Well, if your trust is the primary beneficiary of your retirement plan, and your spouse is the primary beneficiary of your trust, and it's a conduit trust, then there's no question the spouse gets to use his or her life expectancy to calculate RMDs. That's easy. Well, what if your trust is a Q-tip? What if for any number of reasons there's a non-marital trust created at the death of the first spouse, it inherits the retirement plan, and it has Q-tip provisions, not conduit, what we typically think of as conduit provisions? Well, it depends. If the Q-tip says to the trustee that you have to distribute the greater of RMDs or income, then the spouse is going to at least get a forced RMD every year. They may get additional money. If the income is greater than the RMD, then sorry, my wife was sending me a text of something I need to make sure I clarify. I want to make sure I see that. Thank you, Laurel. I will talk about that. So if the Q-tip says you have to give either the greater of the income or the RMDs, then the spouse is at least getting their RMDs, so they're able to use their own life expectancy to calculate that. And then there's some question, and again, this is me kind of giving my best guess. There's some question about whether or not the spouse gets their life expectancy if it's an accumulation trust. If the trust authorizes the trustee to hold RMDs, even if the spouse is the beneficiary, then it may very well be that they're subject to the 10-year rule and not able to use their own life expectancy to calculate their RMDs. Now, Here's the note that Laurel, my wife and law partner and co-owner of the firm, sent me. So one point of confusion early on with the Secure Act was whether or not the RMD was still an annual requirement. And the answer is no. The RMD is required only in year 10. And I'm going to talk about this in a little bit more detail on how to avoid this problem down the road, but I still want to go ahead and flag it in case you don't know. So under the Secure Act, an RMD is something that only has to be distributed in year 10. It's not something that gets calculated along the way. So if you are a designated beneficiary, meaning you don't get to use your life expectancy, you're not an eligible designated beneficiary, you're just a normal person who receives an inherited IRA, your RMD only applies in year 10, not in each year along the way. So if you have a trust that says to your trustee, you have to distribute RMDs, but you can only distribute RMDs. There's no other discretionary distributions or withdrawals from the trust. Then everything is held in trust until year 10, and in year 10, everything is distributed to the beneficiary, and it all becomes taxable income in 1 year, and we have a massive income tax hit all at once. We'll talk about how to draft around that in just a moment, but that's an important note. What if we have a child, a minor child that's a beneficiary? This could be your own child, this could be a grandchild, niece or nephew, or just an acquaintance. But if you have a minor child that's named as a beneficiary of a trust that is inheriting an IRA, then how do we make sure they also get to use their life expectancy? Well, it's pretty clear that until that child reaches the age of majority, they're using their life expectancy to determine, how this has to be distributed. Once they reach the age of majority, then the 10-year rule applies. So you may, if you're drafting revocable trusts and you're counseling your clients to think about, modifying the age of majority or minority to delay an outright distribution, for instance, at some later date, you may, inside of your revocable trust, say anybody under 25 years old or under 30 years old is going to be considered a minor, and everything will be held in trust until then, and then there will be an outright distribution at that point. You can redefine minor status for purposes of non-IRA distributions all day long in your revocable trust or even your SRT, but you cannot use your trust to redefine minors for purposes of the 10-year rule. So let's say you have a revocable living trust that says every beneficiary under 30 years old is going to be considered a minor and everything will be held in trust for them until that point. Then that would apply to your brokerage account and your real estate and other kinds of, life insurance proceeds, etc. But the 10-year rule for inherited IRAs would still kick in when state law says that person is no longer a minor, 18 or 21. So you can't draft around that provision with your RLT or your SRT. So you might want to consider whether or not asset protection by creating an accumulation trust is a better way to protect those assets during that 10-year time than creating a conduit trust with discretionary provisions, and we'll talk more about that in just a second. So one question here, we've talked about the concept of what a standalone retirement trust is and how the Secure Act affects all of this. But one question that comes back to us pretty frequently, sometimes from financial advisors, is do we have any business naming a trust as a beneficiary of an IRA? Get the trust out of this because it creates more problems than it solves. Let's just name individuals as beneficiaries of IRAs and forget trusts because there's too many ways that this could go wrong. So should we name a trust as a beneficiary of a retirement plan? And like every other legal answer in the world that matters, the answer, of course, is it depends. So the first thing we need to consider, as I'm going through this analysis with clients or with financial advisors, should we name the trust as a beneficiary? We need to think, first of all, about who our ultimate beneficiaries are. Does the client want to distribute everything to non-designated beneficiaries? Does it all go into charity or to a church anyway? Do we have only designated beneficiaries? Do we have any eligible designated beneficiaries? Do we have a mixture of all of the above? Depending on who the client wants to receive these assets downstream, then naming a trust or creating an SRT, becomes we have a decision tree to apply here. It's not a simple yes or no. So we need to think first of all about income tax consequences. if we're using conduit trust provisions, so if we have designated beneficiaries with conduit trusts, somebody is going to have to pay the income taxes for the growth on this account. If we're distributing income to our beneficiaries, then they get to use their own tax bracket, marginal tax rates, to calculate the income taxes. Under the current law, an individual beneficiary would have to make more than $518,000 a year, or a married filing jointly would be $622,000 a year. They would have to be making a really high income to be subject to a 37% tax. It's not likely, in most cases, that the income generated from the retirement plan that gets distributed to them is going to put them at that high of a tax bracket. So it's going to be much more tax efficient, whether you're naming individual beneficiaries or a conduit trust. It's going to be tax efficient to name individuals and with conduit trust provisions as the beneficiary of the IRA. If you have a desire to create an accumulation trust, maybe with a special needs beneficiary, some other asset protection concern, you've got beneficiaries with substance abuse problems, etc., gambling addictions, you may want to create an accumulation trust that does not require distribution of anything to the beneficiary. It's all at the trustee's discretion, including RMDs. Well, the thing to keep in mind is that the trust is now going to have to become the income taxpayer. They're going to file a 1041, a fiduciary return now, to pay the income taxes on the IRA. And the marginal tax rate for a trust gets to that 37% bracket at $12,950 in 2020. So if the trust creates, if the IRA creates $13,000 worth of income in a year, anything over that's going to be subject to a 37% tax, income tax. So one of the things that we have to weigh with clients when we're deciding whether or not to name a trust as a beneficiary is, what kind of beneficiaries do we have? Are we creating conduit versus accumulation trust provisions? And what kind of income tax consequences is that going to create? Now, the client may very well prefer the asset protection afforded by an accumulation trust, even though it creates a higher tax consequence than the tax efficiency that's created by the conduit trust provisions. Some other considerations here are you including charitable organizations? So a lot of times clients might want to make sure that their church or a charity becomes a beneficiary of an IRA because it's a very tax efficient strategy. The client has never paid income taxes on this money, and if it's distributed to a charity, then the charity doesn't pay income taxes on it either, and that's a really tax efficient way to transfer maximum dollars from your estate or trust to your charitable beneficiary. The potential downside is if your trust doesn't give your trustee really specific instructions, and if the trustee isn't very sophisticated about that, they may create a cascading problem for all the other beneficiaries. For instance, if your trust says 10% of my IRA is going to my church and 90% divided among my kids, and the trustee waits too long to make that distribution to the church, then everybody is subject to a 5-year distribution. We don't even get the 10-year rule at that point. Everything's got to come out within 5 years. So what we try to do inside of our trust is say, to the degree that any charitable beneficiary is named here, they need to get their distribution before September 30th of the year following the plan contributor's death in order to avoid that 5-year forced rule for everybody. So if you're naming a charitable organization, that can still be fine, but we need to give very clear instructions to the trustee to make that distribution quickly, so that all the other beneficiaries are potentially able to stretch that benefit out as long as possible. Do you want to ensure ongoing tax-deferred growth? So one of the things that naming the trust as beneficiary can do is force all or some of the principal to remain invested so it continues to grow tax-free. If you just name the individual outright as beneficiary, then you're avoiding some of the trust drafting complications, but you're also potentially cutting off all that potential tax-deferred growth because beneficiaries are likely to take that money out very, very quickly, sometimes within the same year they inherit it, which not only creates a massive income tax consequence, but also cuts off that future tax-deferred growth potential. And then, of course, under Clark v. Ramaker, are we concerned about asset protection? So if you've got a client who is in a rocky marriage and potentially going to be going through a divorce, is constantly battling creditors and considering filing for bankruptcy, is in a high liability industry and maybe getting sued. They're a business owner, a surgeon, a truck driver. Then their potential future liabilities could expose the inherited IRA to loss, and the client may in fact want to preserve those assets from their beneficiaries' financial bad luck or bad choices. And trust is our best tool to do that with if it's properly drafted. So these are some of the things we have to weigh when thinking about whether or not to just name the kids as the beneficiary or go ahead and name the trust. What type of beneficiaries do we have? Is a charitable organization a part of the mix? Do we care about the ongoing tax deferred growth, the annual income tax consequences, and ongoing asset protection? And some maybe more getting into the weeds drafting considerations during now that SECURE has passed. Can we switch, if the grantor creates a conduit trust provision, can the trustee switch to accumulation trust at some point uncertain in the future? If the grantor becomes incapacitated or passes away, can the trust give the trustee the ability to toggle between conduit and accumulation provisions? Maybe the circumstances in the beneficiary's life during when the grantor created the trust are different now that they're incapacitated or have passed away. Well, we're unsure right now how the IRS would treat this. If the trust said to the trustee, you've got a conduit trust here for the beneficiaries, but if any point in the future you want to switch this to accumulation, I give you the authority to do that. Without clarifying a time frame or a reason, we're not really sure yet how the IRS would treat that. Would they allow the switch from conduit to accumulation or vice versa? We don't know. But that's one of these provisions that sometimes shows up in trust, and now that SECURE has passed, I'm not sure whether or not that's going to be enforceable. We need to wait on some regs to see. One thing that we do know, some of you may have used or know about the Keebler switch, right? Good old Bob Keebler has done a lot of heavy lifting for retirement trusts in the last 15 years. So in 2005, he was a part of a team that got a PLR for allowing the trust protector to void conduit trust provisions and switch to accumulation trust provisions, and even amend a POA if done within 9 months of a plan contributor's incapacity or death. So we have a time certain, and we have the trust protector acting, not a trustee. We have at least a private letter ruling that says that this is an allowable tool to use, that the trust protector within 9 months of a plan contributor's death can switch from conduit to accumulation trust. It's a 15-year-old PLR, but there's nothing in the SECURE Act that would contradict that ruling. So I think we can still create that power inside of the trust. If you do create a conduit trust, have a trust protector in place that has the authority to switch to toggle over to accumulation provisions, and we think that would still be enforceable post-SECURE. What about powers of appointment? We want to be really careful with this one now, and this might also be a really good reason why you might want to split the revocable living trust and the standalone retirement trust into two different piles. So what happens if you've got a revocable living trust that gives a power of appointment, maybe a lifetime or a testamentary power of appointment to a designated beneficiary to name a non-designated beneficiary, like a creditor or a charity? If you have a see-through trust and the RLT receives the inherited benefit and it sees that a designated beneficiary has the authority, has a lifetime power of appointment to name a charity or a church or a creditor as their as an appointee, does that force a 5-year rule for everybody? Well, it very well may. At the very least, it may turn an eligible designated beneficiary into a non-designated beneficiary. So we want to be really careful about this. If you have a client who, for any number of reasons, wants to grant power of appointment to their beneficiaries, maybe to preserve a step up or something like that, then I would especially take this as a good value proposition to your client to consider drafting a standalone retirement trust to receive the IRA benefits. Because if you want to give that power of appointment over life insurance and cash and brokerage and real estate, you may very well not want to grant it over the retirement assets because you don't want to force this the 5-year rule. So if you're granting powers of appointment in a revocable living trust, separate the death or the beneficiary of the IRA into a standalone retirement trust, and do not grant those powers of appointment, at least not to non-designated beneficiaries, because we don't want to force this 5-year rule. So something I hinted at a moment ago, if one way, or let me back up and say it this way. Again, under the Secure Act, the RMD only applies to year 10. It's no longer an ongoing yearly distribution. It's a year 10 distribution. And you need to decide and counsel your client and possibly talk to the client's accountant or financial advisor as well, or plan administrator, whether or not you want to have language in the trust that allows the trustee to make discretionary distributions or allows the beneficiary to make withdrawal rights along the way. If you don't, if you say the only money that can come out to the beneficiary is the RMD, then you are forcing everything to stay in trust until year 10 for it to come out all at once and then to take a big income tax hit in that single year. So if one of the things you want to do is protect those assets for as long as possible, then know that you are creating a tax issue as a trade-off for the asset protection. If one of your goals is tax efficiency, then you need to allow for more than just the RMD. You need to either give the trustee the ability to make discretionary distributions along the way of a certain percentage of assets or possibly for certain purposes, so that the income can be taxed in smaller increments as it's distributed to the beneficiary. And that way we're not taking a big tax hit all in year 10. But the trade-off there, of course, is every distribution you make, now we have no asset protection over that portion. So depending on your client's sensitivities and values and priorities, and depending on the amount of assets, you may want to counsel with your client about this trade-off between asset protection but loss of tax efficiency versus tax efficiency but loss of asset protection. Now, how do we get beyond the new 10-year rule? If you've got clients who say, my big priority is stretching this out over lifetimes. I don't want everything distributed within 10 years, whether or not my beneficiaries are eligible designated beneficiaries. My kids are healthy. They're not disabled or chronically ill. They're older than 10 years, younger than me. So I want to get beyond 10 years. How do I do that? Well, I've got 3 recommendations here, and there are more, but these are kind of the most common 3 that I talk with my clients about, and I'd love to hear your thoughts. Number 1, you could just name beneficiaries in multiple generations. So if you want to stretch your IRA out for longer than 10 years, name some minors. Name your kids, but also name your grandkids. Name some minor nieces and nephews. So they at least get their life expectancy while they're minors, and the 10-year rule doesn't come into effect until after they reach age of majority. So the most basic way to get outside of that 10-year rule is to just make sure that you've included some minor beneficiaries as the beneficiaries of the trust. Now, this doesn't do all the heavy lifting. This just kind of puts a Band-Aid on the problem. It's just a temporary pause to the 10-year rule. The other thing you can do is Roth conversions. I'm careful to tell my clients that I'm not a financial advisor. I'm not trying to tell them whether or not they should do a Roth conversion. Before our clients consider doing this, we always talk to their financial advisor and plan administrator. Depending on the amount that they've got invested and what their own income is, it may be smarter for the client to absorb the income tax consequences now and get rid of this 10-year problem down the road anyway by just converting traditional IRAs or 401ks to Roths during their lifetime. The client absorbs the tax hit now, and then the inherited money is not subject to the 10-year rule because the taxes have already been paid on it. So if you've got a client who either they're at a low income tax bracket or their beneficiaries are likely to be at a very high income tax bracket, the Roth conversion may be something worth considering. It not only is going to lower the tax consequence, but it's also going to allow us to get outside of that 10-year rule as well. Now, the more complicated tool, but one I think that is a lot of fun and is a good fit for some clients is, and I'm just about done, I realize we're right at kind of the 1 hour mark, is using charitable remainder unit trusts. So some of you may have drafted CRUTs in the past for other purposes. I think they work great for stretching out this benefit. So what the charitable remainder unit trust allows you to do is name the CRUT, not an SRT or RLT, but name the CRUT as the contingent beneficiary of the retirement plan. The CRUT has your kids or grandkids as the beneficiaries during their lifetime, and they get to use their life expectancy under the CRUT to calculate their RMDs. So we're stretching out, the CRUT has to force anywhere from 5 to 50% of the principal in the CRUT every year to the named beneficiaries. So it's never the entire amount, or it doesn't have to be the entire amount. It can be a limited amount of principal that goes to them every year. They report it on their own income tax return, take small hits, allow for tax-deferred growth, but they can do that over their entire life expectancy. The 10-year rule does not apply here. And when they passed away, everything that remains goes to the charitable beneficiary tax-free. So if clients have a significant amount invested in tax-deferred retirement plans, because that's been their big strategy all along because they were investing pre-secure, then a really good way to stretch that benefit out and to make a tax-efficient distribution to a charity is to name the CRUT rather than an SRT or a revocable trust as the beneficiary of the IRA. So with that, I am going to stop my screen share and get back to the chat, and maybe we can turn on mics and see if there's any questions worth asking, or I would love to hear your contributions as well. So
let me give the code. The end code is 2110, 2110. So you've got the halfway code, the end code, which is 2110. And remember, the course number is 112539. So after we do the Q&A here and we finish up, you're going to fill the form out that's posted on the discussion page and send it in to Beverly Petrie. And the materials that Riley just worked off of are also on the discussion page. They may have been posted as early as last week, like last Friday, but if you'll look down on the discussion page, you'll see these materials if you didn't see them before. So, yeah, Riley, let's do some Q&A and see what the folks have got to say for you. And if you're going to ask a question, feel free to take your microphone off. I mean, turn it on so you can ask the question if you want to do that instead of writing it out. Either way is fine.
Dan, there's a question from Garrett Eller. You want to read that to him?
Sure. You see it, Riley? Do you see it?
I see a couple from Garrett. One's about remote contingents, and one is about allowing distribution for mortgage, etc. So I guess let me take them both. And then Stephanie, I see your comment too. I'd love to hear your thoughts on that. So Garrett, can your remote contingent distribution be a non-identifiable beneficiary and it still be valid and not trigger the 5-year rule? So my understanding is that if it's a see-through trust, the IRS is going to look to all beneficiaries, including contingent or remainder beneficiaries, and they're going to try to find the last beneficiary that doesn't allow them to calculate any kind of life expectancy. And if they find one, then the 5-year rule applies to everyone. That's my understanding. I would be happy to be proven wrong, but the people that I've read and listened to on this have said something similar. That the risk, of course, is if your remote contingent beneficiary includes anybody other than an individual or class of individuals with an identifiable life expectancy, then you are risking the 5-year rule for everybody. So again, I think this is a great reason to divide between the RLT and the SRT. If your RLT, the client wants to use, church or charity for ultimate, taker of last resort, remote contingent beneficiary, then the SRT that does not include that potential beneficiary is a good way to make sure that we're not even raising this risk of the 5-year rule for everybody. Again, I want to answer Garrett's other question real quick to the best of my ability, and then if anybody has a different understanding, I promise my feelings aren't hurt. I would love to be corrected on that point. And then Garrett also asked, under conduit trust option, can you direct the trustee to use the RMD for the benefit of the recipient solely to pay for creditor bankruptcy protected bills, assets, mortgage payments, utilities, etc.? So my understanding is no. If you're requiring the trustee to use that money in some way other than making a distribution directly to the beneficiary, then this is not really a conduit trust. This is an accumulation trust with direction to use the income for the beneficiary for particular purposes. So I don't think so, and I think if you did direct, if you positively directed the trustee to make a provision directly for a creditor, like a mortgage company, bankruptcy, etc., you're kind of creating the opposite of a spendthrift provision. You're giving any creditor a legal argument for getting in and having those assets be exposed to loss and losing the asset protection. Again, that's my understanding. I'd be happy to hear some color or some nuance if anybody has a different reading of the law or understanding of how that works. I'm going to take the silence as a no or a lack of interest, which is both are fine. Now, Stephanie Allman had a note. We thought minor only referred to the minor of the employee, a child of the employee who has not reached majority. You might be right. My understanding of how minor is defined as an eligible designated beneficiary and secure is any minor beneficiary named as a beneficiary of the trust. It does not have to be the child of the plan contributor. But I'd love to read that. The citation you mentioned is something that defines designated beneficiaries, and I think that's important for calculating the 10-year rule, etc. Let's see, Terrell, Stephanie's point appears correct as to ERISA plans, but may not be true for non-ERISA. So, yeah, there's going to be some nuance here when we're talking about asset protection, especially between 401ks and ERISA plans versus, traditional IRAs and other types of plans. So, that same nuance may apply to Stephanie's point. Thank you, Terrell, for pointing that out. What other questions? Does anybody want to ask one out loud, or we want to just kind of keep going through the chat and seeing what's there?
It looks like the chat's kind of where they are. So
yeah, chat's lighting up. So let me just kind of find a few. Let's see. Some of the most recent ones. What do attorneys charge for standalone retirement trusts? I'll let you guys share that information privately if you'd like. Is there a way to use a crummy type strategy to move the money from the retirement trust conduit to an accumulation trust to continue to hold and protect assets? I think so. I think that's a really interesting question. One way to kind of create that crummy type strategy, which doesn't make it a distributable gift for a period of time, but that Keebler switch, allowing the trust protector to switch from conduit to accumulation is a powerful tool. I have not drafted an SRT with something like a crummy power that allows a period of time for a distribution to be made, and then if it's not taken, to be switched over to an accumulation. But I think that's a really fascinating idea, and if anybody wants to weigh in on that, I'll certainly shut up for a minute and provide room for that to happen. And thank you, Scott, for the note you said there on clarifying on Stephanie's question. ERISA minors does seem to be excluded to minor children of the plan contributor, but Congress is talking about moving that to all minors. Michelle Robnet, are we saying to create the SRT at the time of the participant's death out of the RLT, or is it trust created now and named as beneficiary of their rights? It's a trust created now. So the standalone part of it, standalone retirement trust, is it's a trust created now and funded with kind of the legal fiction of the $10 cash, right? It's legit because it owns the cash in the grantor's back pocket while they're alive, but it's essentially an empty bucket that receives assets at the plan contributor's death or the death of their surviving spouse, depending on whether it's the primary beneficiary or the contingent beneficiary.
Yeah, Riley, I think we're going to have you back for part 2. Everybody seems to really enjoy this, and
Oh, I'm glad.
we're really, grateful for the input. Yeah, thanks for volunteering too. It was very helpful.
Oh, my pleasure. And I'd be happy to interact by email if anybody wants to do that or set up a little conference call privately. And again, I love being, having things clarified in my mind. So if you've got additional notes or clarifications for me based on your experience, I'd love to hear it.
Well, I don't see any more questions, and I think we're kind of all the way through your material. So let me thank you on behalf of the OBA PPT for your presentation today. I think we had a great turnout, and we didn't have a whole lot of difficult interruptions with the cars and the emergency vehicles sounding behind us. So Riley, we just thank you a lot for your presentation today.
Thank you, Dan. Appreciate the invite.
Yeah, glad having you. Okay, we're all done. Thank you,
all right,
guys. Turn in your forms.